Great. Our next tip is about how to properly monitor your trademark or trademarks. And why monitor your trademarks, you might ask? Well, because the best way to know about and to be able to deal with situations, most notably infringements of your trademark, is to monitor and to be proactive. Properly enforcing your trademarks against those who are using it without your consent or who are using something that is similar enough to be likely to cause confusion amongst your consumers is a problem with your trademark, and it's key that you go after such uses in order to keep your trademark as strong and as valuable as possible. And generally, going after such uses quickly, even before they've been invested in a lot, perhaps before anything's even been sold, makes it a lot easier and a lot quicker generally to deal with this infringing situation, because the other party has yet to invest a lot of resources, a lot of time, a lot of emotion in this name, this brand, and so the chances of coming to a quick resolution should be a lot higher. So monitoring provides a lot of value to your trademark in order to quickly become aware of these potential situations and then be able to act upon them. Remember in monitoring, and we're going to discuss some actual ways to monitor, that you're not just looking for identical trademarks, but you're looking for things that might be slightly different in sound or in spelling, plural, not plural, with a space or with a hyphen or without a space. All of these alterations to a name could still be very, very similar and very likely to be confused, depending on how strong the name is and how similar the goods and services are, as Mark spoke about a little bit earlier. So monitoring, easy ways to monitor. Set a reminder monthly or quarterly and do some searching. You can search the U.S. Patent and Trademark Office. Their website is www.uspto.gov. You can search the internet. Use several of your favorite search engines. Don't limit yourself to one because they all work a little bit differently. You can search Twitter feeds, other social media feeds these days where so much activity is happening. You can search domain name registrations through domain name registrars. Another great place to search is if there are any directories or industry resources within your industry that are prominent and used and feature listings of most of your competitors. That's a great place to start, because most likely a competitor, a potential infringer, would show up on that website or in that directory. So set a reminder to search these types of things, again, monthly or quarterly. Remember that while you can do a lot on your own searching, there are also professionals that do it, lawyers and other search firms, and that really is something that should be considered, particularly as your brand grows in prominence, grows in strength, grows in value. A professional search company can do a lot more sophisticated searching and reporting, but at a minimum, you should do it on your own. Our bonus tip for the trademark monitoring section here is to, through Google and Google Alerts, I believe it's at www.google.com/alerts, you can set a automated search tool that will email you results daily or weekly or whatever settings you choose with key phrases or key words in it. And so you can put your trademark, put your brand name, put alternative spellings in there perhaps, set up a couple of alerts, have it email you daily or weekly for the instances that it finds. This is a great tool to see how others are talking about your business, perhaps, and to make sure that they have permission if they're using your trademark, or to see if anybody pops up with anything similar out there. Our next essential trademark tip builds upon your monitoring, which is, what do you do if you find a possible infringement? Well, the first thing you want to do is act quickly. As I noted before, the less time and money and emotions another business has invested in their brand name, the better chance you have of resolving a dispute with them quickly. And by resolving it quickly, I mean spending less money and less time and less attorney's fees on it. Of course, if there is an infringement situation, it is strongly advised that you consult with a lawyer for an opinion and for advice and perhaps for action. The first step generally after evaluating a potential infringement situation is to send a strongly worded letter. These letters are commonly called cease and desist letters, and they generally will give some background about the trademark owner and give some background about trademark law to the company that's receiving it, and then make some demands that they change their name, that they cooperate with your list of demands, that they change their packaging, that they transfer their website, whatever the appropriate demands are given the situation. When we send cease and desist letters, we receive and respond to cease and desist letters on behalf of clients every week. When doing so, I think it's very important to realize that the goal of the letter is to reach an agreement, to reach a resolution of the problem, rather than to reach a dispute that ends up in court. And so a strongly worded letter is important, but also being reasonable and holding out something, perhaps a carrot, that will allow this to be resolved and negotiated in the short term and without expensive legal fees or litigation is generally beneficial to everybody involved. Maybe not the lawyers, but everybody else involved. Remember that if you find out about an infringement, if it's brought to your attention or you become aware of it, and you don't do anything, you could be limited in your options later to do something. This is a legal doctrine called latches, where basically if you're aware of a problem but you don't take action, your rights, your ability to take action later could be severely diminished because the other company, had reason to believe that you would have objected. You would have told them if you had a problem with their trademark, and you didn't, and they perhaps reasonably continued on doing business, perhaps reasonably believing that you did not have a problem with their trademark. Also remember that if you do nothing, and one potential infringer is allowed to use something reasonably similar to your trademark, others might believe that they could get away with using something else as well. And so these things can sometimes multiply, where you have one infringer that's arguably similar, you do nothing, then another one pops up, then when you contact the second one, they say, well, what about the first one? You didn't complain to them. I mean, if you don't see that as a dispute, how are we to dispute? Then all of a sudden you've got multiples, and it's harder to make a claim of infringement when you're dealing with multiples, because your sphere of protection could be narrowed. Another thing to consider when sending a cease and desist letter is that your letter could be made public. It could be posted. It could be posted online. It could be posted on Facebook. It could even go viral. There's been several cease and desist letters and trademark disputes in the last few years that have gotten some considerable media attention, and the lawyer's documents or the parties' communications have sometimes been posted online as a way to try to gain leverage, gain publicity, or embarrass the other party. Bonus tip, as I noted, the quicker you deal with an infringement situation, the quicker you take action generally, the easier and the cheaper it is to make it go away. So I really strongly repeat that message. Mark, for our next tip.
All right, so the fifth tip is getting a registration, a federal trademark registration. A lot of people don't know, well, you have rights without a federal registration, but those rights are very limited compared to what you get with a federal trademark registration. So there are many reasons to get federal registrations. First of all, these common law rights that you get from using your mark without a registration are limited to the geography, the area where you're using your mark. And if competitors are starting up elsewhere, they've got equal rights as you if they're using it somewhere else. Furthermore, they could go get a federal registration, and that federal registration gives you nationwide rights. And so if you are planning on expanding ever, and maybe people don't plan to expand, but people hope they expand sometimes, or always, you want to have that option, and a federal registration gives that to you. When you have a federal registration, you are presumed to have the exclusive right to use that mark anywhere in the United States, whether you are using it outside your state already or not. And so it puts others on notice. It puts others, it makes other people aware that your mark has been claimed. They can find you in the register, and they can decide to pick a different mark. It puts people on notice that that you have a stronger ability to enforce your mark. You have lots of evidentiary presumptions that are in your favor. If, God forbid, it comes to a dispute, there is a higher burden that someone else is going to have to meet to defend themselves against you, and you have a lower evidentiary burden that you would have to meet in order to make a claim against somebody else. And that itself deters a lot of disputes. It also prevents other people from registering similar marks. The Patent and Trademark Office will do a little bit of your work for you. If someone else tries to go register something that's too similar to yours, and on similar goods or services, it will likely get rejected by the USPTO. Now, it doesn't always. You still have to keep track of it yourself, because there are a lot of things they won't reject for, but it gives you this extra line of defense that prevents disputes further down the line. And then, and of course, your mark turns up a lot easier in other people's searches. Now, a bonus tip here for this one is that you don't have to be using your mark already in order to start the application process and to start claiming rights in your trademarks. There is a process called intent to use application, and what it does is when you file at the U.S. Patent and Trademark Office based on your intent to use a new mark, say you're about to roll out a new product in the near future, you can reserve rights in that name. You won't be able to enforce those rights yet until you start using the mark on that product, but it locks in your date, and from the date you file, anyone else who attempts to file for the same or similar mark, or starts using the same or a similar mark after that filing date, will have to come through you first. You'll have what's called priority, and that's the date that your rights become valid. So once you start using that mark, once you get that product finally rolled out, you'll know that you'll have secured rights in that trademark before you make all the investment in the marketing. So yeah, we'll throw it to Eric for the next issue.